Oh, thanks, Vince. Thanks, Mark. So thank you all for joining us today. And I certainly hope by this time next year, we'll be sitting down together, uh, enjoying meatballs and smoked salmon. So today I'm going to talk about personal property distributions. And I can't promise you that this is something that's going to avoid family fights, but it's going to diminish them. So, what are we talking about here? Personal property distributions are allowed because the Wisconsin uh, probate code and the trust code allow these. And we're talking about the things that you can put your hands on, tangible personal items. As you can see on the slide, we're talking about your household items, includes automobiles, and sometimes these items don't have a great deal of financial value, but they have a great deal of sentimental value to your family and your friends. Now, in the plans that we draft, either a will or a trust-based plan, we have our own definition of tangible personal property, which pretty much is consistent with what the Wisconsin law is. Next slide. So the ways that this can be distributed is by a memorandum. You could leave it up to your trustee or your personal representative, or you could do a combination of both of these. Next slide, please. So there you see a memorandum for a married person, and that's for a trust. If you have a will, it'll be very similar to that format. Now, for a married couple, there's a third column where the asterisk is shown. And the reason that that column is there is, say you have a married couple and the wife dies first, and there's a dining room table that's supposed to go to a daughter. Well, you'd want to indicate that that does not get transferred if the husband survives, because he's probably going to want to still use that table. In other instances, there might be hobby equipment that the surviving spouse no longer needs, and that could be distributed to a beneficiary right away. Now, this document is usually in the last tab of your trust binder and the last tab if you have a will binder. And I noticed when we do our reviews, and now I've been doing these trust reviews for over 10 years, and very seldom do I see these forms filled out. So I hope I can encourage you to take a look at these and maybe take a second look at whether you should fill these out ahead of time. Next slide, please. So if the memorandum, and it's not normally going to cover everything unless you make a blanket statement that says all of my tangible personal property to such individual, it's just going to highlight those items that you're more concerned about. So if it doesn't include everything, oftentimes we'll have language that'll say that your children or other individuals should receive the tangible personal property in substantially equal shares. And we try to give them an opportunity to agree to the things that they want. Next slide, please. If the recipient is a child that can't make their own decision, normally we'll have a provision that someone can step in and make a decision for those children. And if at any rate no one can decide within 6 months of the death where the property is going to go, then the trustee can make that decision for the individuals and is held without responsibility for the specific distribution, as we can see in the next slide. So the trustee then, and the same would go for the personal representative, can come up with a system such as a lottery system, rotating who makes choices, anything that really is fair under the circumstances so that individuals that are supposed to get an equal distribution of this type of property are treated equally. And then also, after the items that are distributed that the beneficiaries want, then the balance can be sold and the proceeds from the sale would be split in the proportion to the provision in the either the trust, the will, or in the memorandum that talks about how things are supposed to be split up. Next slide, please. So this is what I was talking about before. The trustee is held harmless as long as the trustee or the personal representative uses good faith in helping to transfer the property. For instance, oftentimes the trustee or the personal representative will also be named as a person that's going to receive some of this property. So if they make decisions that benefit them and don't benefit their siblings or other relatives equally, there might be a problem. But normally, if they're trying to do their best to treat everyone fairly, there's not going to be any issues with this memo. Next slide. So the whole idea here is to take advantage of a planning opportunity that can avoid a dispute. Now, we can't assure you that if you fill this form out, that everyone is going to agree to the way they were treated. But oftentimes, coming from you, it'll have more weight as to where property is supposed to go. So again, I urge you to look at in the last section of your trust binder, or if you have a will-based plan, the tab that has the memorandum there, and take a second look as to whether you should fill that out and help your trustee or personal representative from having to make all of the decisions in this regard. Thank you very much.